Hi guys, welcome to my visual presentation on IP. I'll be focusing on two, sometimes different yet conflicting perspectives regarding IP, and from there I'll break my discussion into the four kinds of laws as discussed in the lecture. The two perspectives are the consumer and the business. Tension between the consumer and businesses are common because the consumer wish to get products with good value for money, and businesses want to profit from their sales to consumers by buying low and selling high. My personal perspective tends to veer towards the consumer, but I also understand the concerns of businesses. The first law is copyright, and it protects original works of authorship or artistic expressions of ideas in a fixed medium. From the consumer perspective, consumers are mainly interested with the price of a product as well as its perceived value. As a consumer, if I feel a product or innovation is good but costs too much to purchase it, I will look for alternatives. And in this digital society, I admit I would turn to piracy by downloading content from third-party websites or P2P networks. Yet without IP laws, piracy will only discourage content producers from producing content we need and love. For example, imagine a drama series that was left hanging without any follow-up because they discontinued the series. Imagine how that would make us feel. Frustrating, isn't it? Parodies are interesting because prosumers or other producers take inspiration and ideas from original works and turn them into comic entertainment. Parodies pay homage to original work by critically rethinking the ideas presented in a comedic way where everyone is able to enjoy. On the business perspective, copyright allows businesses to claim ownership and originality to their work. It makes producers responsible for the work they produce. Thus, content producers are urged and pressured to publish work which are socially responsible and factual. Freedom of expression isn't really free, only to the extent it is not injurious to other groups in society. For us students, having a producer copyright their work makes what we say and write about in our projects more credible because we cite reliable sources of information. Yet as mentioned, even with laws, piracy of information and content is still high. But in my opinion, in spite of piracy, companies are still turning profits. So even if I, or many others around me, pirated content, these companies don't seem to be suffering much. In fact, I think piracy is a way some groups in society put up resistance against big MNCs which tend to exploit workers for minimum wage. And in a way, it seeks justification for themselves. Even if we did these companies a favor by stopping piracy, would they thank us for it? Moving on to patents. Patents protect new, useful inventions and processes. From the consumer perspective, most consumers would find that patenting processes in a product can be counterproductive and have social consequences, such as the impediment of the development of life-saving technology, and it can be seen as a political economic move to change laws just to benefit laissez-faire capitalism, especially when businesses take advantage of the law to their own ends. For the business perspective, it can be broken down into the originator, the one who created the product or process, and its competitors. For the originator sides, quality of the product, preserve the authenticity of method, royalties can be earned, and it raises barriers to deter competitors. On the other hand, if competitors are able to purchase royalties, there can be competitive collaboration, which catalyzes industry development or newer innovations. As I mentioned, it is only limited to companies which can afford paying royalties. On the flip side, idea generation becomes stagnant and too costly to undertake. Trademarks. They protect passwords, names, symbols of manufacturers to identify goods or services. And exemptions to the law can be granted if a similar trademark is used in another geographic region or industry. From the consumer perspective, it allows the identification of reliable brands. It allows informed decision-making about the product or the credibility of a source of information. However, even with exceptions to the law, consumers can still get confused. For example, when I mention my internship company, people will think I'm working for a renowned magazine, but in actual fact, it's only a research company in a completely different field, which specializes in quantitative research and analysis. Businesses can take advantage of reputable brands to tap onto the credibility and generate revenues for themselves. This can be done by posing or even counterfeiting products. Under the surveillance and regulation of law in the US, misuse or underusage gives the law the right to remove the trademark. Thus, in a way, companies could spend meaningless amounts of time and effort fighting court cases. Trade secrets are laws which firstly protect valuable information which has commercial value against misappropriation, and such information is not generally known by the public and must be subject to reasonable security measures. Imagine, why would the law help you to protect something if you do not take responsibility for securing the information yourself, or if the information is so widely spread about? On a consumer perspective, trade secrets create secrecy and generates curiosity, encouraging prosumers to reverse engineer products that they love. For example, KFC's secret recipe. On a business-to-business perspective, would there be whistleblowing if a holder of a trade secret feels some of the processes are unethical? It could also result in employee poaching, where another company will offer higher salaries or benefits to employees who hold secretive information about their prospective employer. However, there is difficulty in proving that a former employee has breached a non-disclosure agreement. From the business-to-consumer perspective, trade secrets retains consumer loyalty to product because they are the only ones who are able to recreate the product in a way the consumers love. It creates an allure of mystery which helps to market the product, as mentioned, but can be negative when a company does not want the public to know, as in the case of Twinkies. Steve Ediger, author of Twinkie Deconstructed, came up with a list of 39 ingredients in Twinkies without the cooperation of Interstate Bakeries Corporation. He notes there's no cream in the filling and maybe only 1 out of 500 of an egg in each cake. Imagine if that you want to eat this tasty yellow snack for yourself or give it to your kids. Would you really want to dwell on the fact that it's created from ingredients such as polysorbate 60, high fructose corn syrup, red number 40 dye, and sorbic acid? In conclusion, there will always be debates between upholding intellectual rights versus upholding consumer rights. However, I feel consumer rights are applicable to the extent it does not encourage infringement, and intellectual rights are applicable as long as it does not enforce in a one-sided way only to benefit producers. And I feel the concept of relativity should be employed when nothing is inherently good or bad, just what we do with it which gives the act a moral character. For example, being rational and analyzing the costs and benefits of doing an act, for example, piracy. And also, I'd like to touch on the concept of pastiche, which are artistic expressions of ideas built upon shared concepts. In another light, why do we need to copyright something if all artistic expressions are built upon earlier works and shared concepts? Do we really need to copyright or patent something just because it is slightly different? Who then is really original? With that, I end my presentation, and I hope you have enjoyed listening to me discuss on the different perspectives regarding IP. Thank you.